Hey everyone, Judicial Watch President Tom Fitton here with our weekly update on social media. Thank you as always for joining us. Judicial Watch is in the center of so many legal storms. You're going to want to put your seatbelt on for the show today. New lawsuit against California over election integrity. New details on a court basically holding Fanny Willis accountable to the law in a substantial way, in my view. Plus a lawsuit about Peanut the squirrel. Remember that poor animal that was killed by New York bureaucrats after its owner's home was raided? And plus we have a Supreme Court request to protect Judicial Watch from retaliation and censorship. Pretty basic stuff, right? Important discussion and a lot to go through with you today. First up is, I believe, an issue that is undermining the rule of law and our constitutional structure of government, our Republican form of government, which at the federal level is constructed through three departments, right? The executive branch, the legislative branch, and the judicial branch. And the powers are supposed to be distinct and not reside within one branch, because if one branch has all the powers, the executive, legislative, and judicial powers, that becomes a dictatorship, obviously, to the founders' intent of distributing the powers across the branches in a way that allowed for checks and balances. And all of that means, and the result of that is that our liberties are better protected, because it's harder for any one branch on its own to gain too much power at the expense of our individual liberties. But we're facing a challenge in that regard as a result of anti-Trump animus within the federal judiciary. Now, of course, given Trump's historic and unprecedented and much needed reform efforts, he was going to face pushback in the courts from the organized left. The public employees unions, the Soros operations, the Soros-funded NGOs, taxpayer-funded NGOs demanding more taxpayer money that they say they have a right to, so that we pay them money to sue the government to get more money. That's the way things work in our modern system. And that's fine. You know, people have the right to bring claims to court, and that's why we have a legal system. The problem emerges when the courts start playing politics with these claims and start making up laws as they go along and asserting authorities they don't have. Just in the last week, we had at least two judges assert authority in my view, they don't have, which is to require the President of the United States or his agencies to hire people back by the thousands that they've let go because they were probationary or for other reasons. Now, the last I checked, the president has the right to hire and fire individuals. Obviously, there are constraints. But the notion that employees, in an emergency fashion after they lose their jobs, can go to a federal court and get a federal court to immediately order them to be hired back, that's not the way our system is supposed to work. So I'm not a lawyer, so I'm not going to go through the bases for getting an injunction, an emergency type injunction, or a temporary restraining order. But I can tell you, I think in a summary way, that the relief that's being sought by individuals seeking to get hired back is not available to them under these emergency court actions. There's no emergency. They can wait a few months. They can get their jobs back then, if at all, or they can get compensated. There's no life or death emergency that requires the court to come in and usurp a president's executive powers. Now, I know there have been questions as a result of those types of decisions, and frankly, the Supreme Court, and there have been a few courts that have pared back some of the abusive lower courts, but not enough. And the Supreme Court hasn't done enough in this regard as well, as you may recall with that, in my view, terrible decision by the three liberals plus Justice Amy Coney Barrett and Chief Justice Roberts to essentially allow a lower court to force the President of the United States to spend money on foreigners abroad, despite his best good faith concerns about doing so and wanting to pause it. And he ordered the immediate expenditure over disputed funds. Again, completely outside the judicial norms. And so when the judges act like that, and in a way that isn't explained by law and order, and is explained by politics, that's an abuse of power that the framers were worried about. And the response by many to that is, well, can they be impeached for activist judicial decision-making in a way that undermines the rule of law? And the answer to that is yes. And I wrote an op-ed for Judicial Watch for the Washington Examiner. And the headline, and it's worth going over, because just because they can be impeached doesn't mean they will be impeached, or it's really, practically speaking, politically possible to impeach them. But it's worth highlighting that impeachment is a tool given to us by the framers, not because a judge is corrupt. I mean, that would be covered by impeachment, but because a judge exercises powers not available to him in the Constitution in an abusive way. And the headline of the, I think the Examiner came up with this one. I don't remember if I did this headline. The constitutional option, impeachment of activist judges. And I highlight, these issues that I was just talking about. And, as we detail in the op-ed, when judges start to act as president, that's something that the Constitution frowns upon. Because as we say, Article 2, Section 1, Article 2 is the section of the Constitution that largely explains the president's powers, the enumerated powers. Article 2, Section 1, Clause 1 of the Constitution unambiguously states, the executive power shall be vested in a President of the United States of America. Not in judges, not in Congress, but a president, one man. Powerful position when you think about it in that regard. And this is in explaining what is now known as the vesting clause, the powers vested in him. White House Deputy Chief of Staff Stephen Miller said, a president is elected by the whole American people. He's the only official in the entire government elected by the entire nation. And the threat to democracy, as Stephen goes on to say, and he understands it's a constitutional republic, but it's a constitutional republic with democratic aspects, including the election of the President of the United States. The President is appointed, so the executive power is given to someone democratically elected within the constitutional rules set forth, the Electoral College, the individual state elections, etc. The threat to democracy is the unelected bureaucracy of lifetime tenured civil servants who believe they answer to no one, who believe they can do whatever they want without consequence, and believe they can set their own agenda no matter what Americans vote for. And obviously that's true for many in the deep state, too many bureaucrats, but it's also true for too many judges. There's a great book by Judge Bork, the late Judge Bork, wrongly, in my view, denied a seat on the Supreme Court by the radical left. And I think, what was the name of the book? Was it The Tempting of America? Because I read it now probably 30 years ago. Anyway, you can look it up. And he said the great temptation for judges, no matter their philosophical stripe, is to kind of talk yourself into imposing your political or your policy preferences through your judicial decision-making. And his view was that his philosophy of judicial decision-making was the best guard for that happening, originalism or, a traditional original intent or original intent type approach to judicial decision-making. You try to figure out who wrote what the Constitution said, what it meant when it was written, what those, to a degree, it's unclear, what those who wrote it intended and try to apply it to the current day, as opposed to, oh, I want abortion on demand, so I'm going to just make up constitutional principles that let me get to that result. It's a great temptation. And not only did Judge Bork say you got to resist that temptation, but the founders had a check in place that if you didn't, there was a way to police you. And it was the impeachment power. And I'm not just interpreting this. The founders said it because other Americans were concerned that the Constitution would allow the judicial branch to take over. And they said, don't worry. You can sign on to this Constitution. You can ratify this Constitution because we have these checks in place. And one of the checks, the ultimate check, was impeachment. And let me read you the section of the op-ed that talks about that. Now, of course, I don't have the full. Okay, I'm missing part of the op-ed, unfortunately. Oh, I see what happened here. In persuading the people to ratify the Constitution, Alexander Hamilton explained in Federalist Papers number 81, you can go look it up, number 81 of the Federalist Papers, that while the judiciary may occasionally encroach upon legislative authority, this applies to executive authority as well, its comparative weakness and total incapacity to support its usurpations by force limits the danger. So that's one way, the judges basically rely on people listening to them because, the president has the military and, Congress can ignore them as well. So they don't really have the threat of force behind them. They have to have legitimacy in the eyes of the other branches. He added that this is greatly fortified, this is a quote, greatly fortified by the consideration of the important constitutional check, which the power of instituting impeachments in one part of the legislative body and of determining upon them in the other would give to that body upon the members of the judicial department. This alone is a complete security. So they found or understood and put the impeachment power by Congress for judges at the federal level. They put it there as a complete security for our liberty against usurpations by the judicial department of powers not entrusted to them by the Constitution, executive and legislative powers. Now, the interesting thing is it was essentially just tried once. And as I note in the op-ed, the use of the impeachment power to restrain judicial department usurpations has essentially lain dormant since 1804, when Supreme Court Justice Samuel Chase was impeached by the House for, among other alleged misconduct, tending to prostitute the high judicial character with which he was invested to the low purpose of an electioneering partisan. So he was doing what Americans are generally concerned about, engaged in partisan behavior under the guise of judicial decision-making. That was the allegation. So he was impeached by the House, and there was a lot of politics about that. He was the framers were at each other's throats and the founders were at each other's throats for a variety of reasons there, and he was on the wrong side of one of those battles. But he was impeached. And ultimately, however, Chase was acquitted by the Senate, so he wasn't removed. Now, since then, there have been judicial impeachments, but not because of judicial activism. It's always been, as best I can tell by the history, the impeachments of federal judicial officers have been for misconduct, bribery, that type of thing. lying, obstruction of justice. Famously, Judge Al C. Hastings was impeached and removed. Where he ended up after he was impeached and removed from the federal bench? He was a congressman. He's a congressman for many years. We ended up suing him for a client. He's terribly corrupt. He was a corrupt judge, and then he turned into a corrupt congressman. But the point is, there's been no impeachment for activist judicial decision-making, abusive activist judicial decision-making since 1804. Does it mean it can't be done? No. But it shows you the difficulty of even getting the approval of impeachment of any of these judges out of even the House because of the historical precedent. And obviously, it's always going to be a challenge in the Senate. Now, just because there won't be a trial or a trial will be short-circuited or likely to fail in the Senate because of the partisan makeup, it's not my view that that impeachment should not proceed in the House, because the House has separate independent obligations. If there's an impeachable offense and the majority of the House agrees, then they should vote on it. And then it's up to the Senate to handle it appropriately. So there have been several articles of impeachment, or several judges who have been targeted with articles of impeachment. So that dormancy that I talked about may not last much longer. The House may begin impeachment proceedings, or in the least, this is what I would recommend, that they have hearings on the impeachment of federal judges. Talk about what the process is. Further explain the history that only I was able to get into briefly in an opinion editorial. But, to be clear, we have a right to protect our constitutional republic from lawless judges. And the Constitution gives us a tool to do so. And there are various tools. And one of those tools is the impeachment power. Should it be taken off the shelf and used? I defer to you, dear voter, dear citizen. But I do think it should not be ignored. And we can look at individual judges and see if they've engaged in behavior that would rise to impeachable behavior in terms of activism and just playing politics on the bench. And then, of course, if you're going to do that, you have to recognize that others that you may take a more liberal view, right, of what constitutes impeachable behavior, which is a decision they don't like at all, even if it's lawful and non-political. So, maybe that's one of the reasons that, it hasn't really proceeded much, because it would make judicial decision-making potentially more hazardous in terms of leading to all sorts of impeachment proceedings. But yes, judges can be impeached for activist decision-making. It's in the Constitution, and it was put there specifically for that purpose. So I encourage you to read the op-ed. I put it below. There'll be a link to it below. And, the left is out of control, and my concern is these courts are kind of echoing the craziness in some of their vituperative comments and their decisions concerning Trump. You read some of this stuff and it's like, how is this judicial? It's one thing for me to go on a weekly update and start yelling about stuff and saying things that, maybe the next morning it's like, I shouldn't have said that, right? But judges are always supposed to be judicial, and that means having even keel temperament. So I think there are a lot of temperament issues at issue here, so there may be some ethical issues. I think they've made political statements and criticisms of the president that were unneeded, and just engage. It's basic politics, and there's got to be a pushback some way against that. Either just regular criticism, which is appropriate, or congressional investigation and impeachment. And we kind of see it's probably not the best case, because I confess that the law here, I'm not a lawyer, but I call myself an expert layman in the law, right? I know a little bit more than the average person about legal matters. So President Trump and his team has seen for the last several years, especially since the October 7th massacre of Israelis and Americans by Hamas terrorists, a rising movement, a brazen movement here in the United States by radical leftists on campus and elsewhere to promote and support Hamas terrorism and mass killing. And some of those so-called protests, which are really been nothing more than takeovers in the illegal sense of the word, anti-Semitic, dangerous activities, implicit violence, actual violence, harassment. But many foreign nationals have been involved in those protests supporting terrorism. And let's be simple. I'm not going to kind of go through the statute that allows the president to remove someone who does that. But if you are a foreign national who is a guest in any form or fashion here in the United States of America and you support terrorism, the law allows the president to throw your you-know-what out. And so there was one individual that was arrested, and there will, at the beginning of many others who are going to be arrested and deported for doing exactly that. And so this one guy who's arrested is now being supported by the radical left who likes terrorism, likes political violence, so they don't object to him being a foreign national advocating for terrorist activity here in our country. The elimination of Israel, the mass murder of individuals. Why would we let anyone like that remain in our country? But this is what they want to do. Look at this video here. Is this an insurrection, what you just saw there? It's the president's property. And they're in there supporting terrorism. Literally, someone who is a Hamas promoter. Hamas is a terrorist group, in case you don't know. It's a terrorist group. And it just gets worse and worse. You've got the left-wing terrorists targeting Tesla. I call it a terrorist. It is a terrorist movement targeting Tesla and Elon Musk, who's a federal official, as I talked about last week. And I think there needs to be a comprehensive investigation of that as well. And I was on TV with our friends at Newsmax the other day talking about it. Let's play that.
Let's continue this conversation with the president of Judicial Watch, Tom Fitton. Tom, it's great to see you. These aren't the only allegations against ActBlue out there. I mean, Elon Musk is accusing the Democrat platform of funding groups responsible for the so-called demonstrations against Tesla. ActBlue denies any wrongdoing, by the way. Musk does point out that ActBlue is currently under investigation for allowing foreign and illegal donations in criminal violation of campaign finance laws. Tom, what are your thoughts on all this?
Well, what's really interesting about ActBlue is recently, just in the last week, it's been announced essentially their core leadership has fled. So a lot of their key people are gone, which suggests there was something going on that caused them to flee. And you have to wonder whether these questions about taking money knowingly from sources that they knew or had reason to know were not valid, like from abroad for political campaigns, whether that's the issue that we're concerned about, or as Elon Musk is highlighting, that it's one thing to be funding public policy debates through charitable donations and political operations. It's another thing to be funding terrorism and political violence against your opponents. And what I think is going on against Tesla and Elon Musk is terrorist activity. And it's dangerous, it's violent, and it's also directed at a federal official. The left, as the left reminds us, he works for Trump. He works in the White House. And when you engage in violence targeting a federal official to stop him from doing his work, there are other serious crimes, both criminal and civil, that arise from that.
So, Pam Bondi, Kash Patel, get on it. Get on it. I mean, this lawlessness around immigration, I mean, I guess it's no surprise they would support terrorists being here or terrorist supporters being here. They don't believe in policing the borders. The left believes in open borders. You know, one of the new leaders of the progressive left in Congress, I think we've had her appear here involuntarily as a result of clips, is Jasmine Crockett, a young congressman or congresswoman from Texas. And here's her legal analysis of the legality of invading America.
It is not a criminal violation to enter the country illegally. It's not a criminal. It's a crime. It's not a crime, which is why they're so frustrated.
Look, this woman doesn't know what she's talking about. Member of Congress aside, progressive, radical. It's a crime to cross the border illegally. It's generally a crime to remain here illegally. Criminal violation of law.
I mean, this is the problem with the left, is that they've been pushing this malarkey that being here in a violation of immigration law is only a civil issue. And that's outrageously false. If you cross the border outside the lawful areas that allow border crossings, it's a crime. A crime in the sense you can go to jail for it. It's not a civil crime. It's a crime of, it's a violation of criminal law. Similarly, if you remain here in the United States unlawfully, you're also in violation of criminal law in most circumstances. Not all, but most circumstances. And of course, the sanctuary cities pretend that, you know, subpoenas have to be, you know, issued by a particular court or some other made-up rule that they have to, that they've imposed on the federal government to protect the public, to protect illegal aliens from being, you know, detained and deported by the federal government. And Jasmine Crockett is just a perfect example of that. I don't know, is it ignorance or lies? I don't know. You know, you pick whether she knowingly is providing false information or is not smart enough to know or understand the law. I mean, she's a lawyer. I think she's a trained lawyer. I think she was a lawyer. I'm not a lawyer. It's, you know, the law's right there. You can go read it, look it up. Is there anything else I'm supposed to be talking about related to this issue? I don't think so. But this is what we're dealing with every week. It's like this descent into, it's not kind of going down the rabbit hole, but there, you know, the left is like spinning and, you know, going down the drain in terms of irrational, dangerous behavior. And you kind of think they reached the bottom, but it just keeps on going further and further down. Violence against Tesla, invading Trump's offices, Trump Towers where he lives when he's in New York, is one of his homes. Encouraging lawlessness by a member of Congress. Invasion. Just keeps on keeping on. So the threat from the left to our system of government in the American way continues. And this is why Judicial Watch's work is so important. Not only am I educating, I'd like to think, through this program and our other Judicial Watch activities online and our newsletter that if you're a supporter, you get in the mail, our emails, our text messages, all of that communication. But our work to expose what's happening in our government as a result of this misconduct and this approach to law, this embrace of lawlessness by government officials, going to court to uphold the rule of law in the face of corruption and a disrespect for the rule of law by so many. It's the work is ever increasing. It is ever increasing. I mean, Trump is doing some phenomenal work in trying to reverse some of the worst of the trends. But he's going to have to be in office, or someone like him, with the support of us, you know, a Congress that's much more active than is one now, even though, relatively speaking, this Congress is very supportive. Still a lot more work to be done. And we're going to have, 10, 12 years of the right leadership. And I don't say that in a partisan way. I mean, the big question for America, I think, is will both political parties become American? And my concern is, there are a lot of anti-American vibes within a major political party right now that embraces lawlessness. It's just a factual observation. But we keep our eyes on the ball. There are all these with the Trump administration, and this is the second Trump administration, so we should be used to it now. But this has been extraordinary. All the activity that Trump is engaged in to try to reform the government. Congress is trying to follow his lead to a certain extent. But there are kind of all these issues that are continuing that need to be addressed. And Judicial Watch is best able to address them. And the number one issue in that regard is election integrity. I mean, in my view, Judicial Watch helped stop the steal in 2024, made it more difficult to steal the elections, or even to try to steal the elections as a result of our massive voter roll cleanups and our education of the American people about how the election processes have been corrupted in 2020. So the left at least had they weren't in a position, of course there were others involved in this battle for cleaner elections. They weren't able to steal it. And our work on election integrity was a major contributing factor. The consequence was that we had a more honest and fair election, I'm convinced. And one of the ways we ensure honest and fair elections is through litigation. As we've talked about before, we've sued repeatedly in federal court to ensure that states and localities are taking the necessary steps under federal law to ensure that their voter registration lists are clean. Now, do they have to be perfectly clean? No, but they need to take reasonable steps to keep them clean. And just over the last few years, and the numbers are increasing, even since it's now well over 4 million names have been cleaned from the voter rolls, dirty names removed from the rolls, thanks to Judicial Watch's litigation and legal actions. Another major issue that we've been pursuing is I think something that is a terrible, in terms of undermining confidence in how elections are run. This is a particularly egregious practice, also unlawful, which is the counting of ballots that arrive after Election Day. There are 18, 19 states, maybe the District of Columbia, depending on how you do the counting, that allow votes to be counted that arrive after Election Day. Now, Judicial Watch sued in Illinois to stop that from happening. That case is on appeal. Because they said, I think, the lower court and the appellate court, well, actually, we're asking the Supreme Court to actually to kind of get the case back on track, said that a congressman doesn't have the right to sue to make sure the election rules are being followed. It's just, I don't understand that. And in Mississippi, we had a big case, and the appellate court in that case ruled, again, Mississippi allowed the counting of ballots that arrive up to 5 days after Election Day. And the Fifth Circuit Court of Appeals ruled that that's unlawful. You can't count ballots that arrive after Election Day. And in fact, I just saw that the full appellate court upheld that decision, which is another major victory for cleaner elections in our country. To have an entire appellate court, not just an appellate panel, but the full appellate court of the Fifth Circuit in an en banc fashion, it's called, uphold this lower court decision is a phenomenal victory. I haven't read the decision yet. So go ahead and read the decision. I don't know if we can even find it yet online, but I've been told it came down. But Judicial Watch, we just don't stick to one or two states in terms of upholding the rule of law. proud to announce that Judicial Watch has sued the state of California on behalf of Congressman Darrell Issa to stop that state's counting of ballots that arrive for up to 7 days after Election Day, which, as I've noted, is absolutely contrary to the plain meaning and reading of federal law. The lawsuit was filed this week in federal court in the district of, where was it? I'm not sure where the lawsuit was filed in California. It's filed to prevent state election officials, this is key, from extending Election Day for 7 days beyond the date established by law. So when I say they count ballots for days, count ballots that arrive after Election Day, up to 7 days after Election Day, that's another way of saying they're basically saying Election Day is extended a full week because the voting is still happening and coming in. As we say, Judicial Watch argues that the election law, the California election law, violates federal law, which defines Election Day, and this is what federal law says Election Day is: the first Tuesday after the first Monday in November of every even-numbered year. So that's the congressional version of the law. And the presidential version, obviously, is every 4 years. As far as I'm concerned, I mean, we haven't sued about this. I got my own little issue on this. I think it requires the counting of ballots on Election Day or by Election Day. You got to figure out who won on Election Day. And that was the big issue with 2020, wasn't it? I mean, for the first time in history, we know the President Trump, we had an election decided, or the results changed as a result of post-election day counting. President Trump had the votes to win on election night on 2020. And those results were changed by post-election day counting. And I think that's invalid under this law. But that's not an issue here, so I don't want to distract you. Despite Congress's unambiguous and long-standing statement regarding a single and uniform national election day, our lawsuit says, California modified and extended Election Day by allowing 7 additional days after Election Day for receipt of vote-by-mail ballots. And you remember, surely, that the election wasn't just extended 7 days, but they couldn't figure out who won, supposedly, for a full month plus after Election Day. It made California into a national laughingstock. Indeed, Governor Gavin Newsom just said the other day, he's got a new podcast out. So he's out there talking himself into some trouble. Said it was, quote, right, unquote, to criticize the extended post-election day counting in California, which he called, quote, ridiculous, unquote. So I agree with Gavin Newsom. Not only is it ridiculous, though, I think, and Judicial Watch alleges for Darrell Issa, great congressman, because, not all congressmen want to do this. I give credit to Congressman Issa for wanting to do this. They don't like to sue. You might think they do, but they don't. And one of the issues with the the extended Election Day deadlines in California is that it changed results. It led to different results than were initially present on Election Day, specifically in several congressional races. And Republicans, as a result of this, in my view, shady counting of ballots for a month after the election, lost at least 2 seats. And I don't understand why Speaker Johnson and Republicans in the House aren't investigating those elections more directly and raising the issues that I'm talking about here. But all I know is we can only do what we do, right? Which is sue. We allege the ballots arriving after Election Day, quote, change electoral outcomes in California. The change to the electoral outcomes has been publicly acknowledged by the Office of Secretary of State, which is the California office I'm referencing. Defendant Weber, who is the Secretary of State there, his predecessor issued a press release advising the public to not rely on initial results from election night because late arriving vote by mail, ballots, and canvassing meaning counting, may mean the outcomes of close contests may take days or weeks to settle. So there you had the leading election official in the state of California saying, hey, look, we don't know who won until these ballots that arrive after Election Day are counted. During the 2024 federal election, two of plaintiffs, and the plaintiff here is Darrell Issa, Republican colleagues in Congress lost their re-election campaigns. So these were incumbents that were turned out, which is kind of tough to do, even in unfriendly jurisdictions or congressional districts. Two of his Republican colleagues in Congress lost their re-election campaigns due to late arriving vote-by-mail ballots that arrived after Election Day. Congressman Steele of the 45th Congressional District and Congressman Duarte of the 13th Congressional District in California were both leading in their respective races immediately after Election Day on November 5th, 2024, but ultimately lost re-election due to late arriving vote-by-mail ballots. Again, to bring it back, you can't be counting ballots under federal law that arrive after Election Day. In fact, I played this quick video. It's 30 seconds. It explains the case much more succinctly than I just did. Let's play it.
Hey everyone, Judicial Watch just filed a major new federal lawsuit in California to stop that state's counting of ballots that are received up to 7 days after Election Day. We filed the lawsuit on behalf of Congressman Darrell Issa, who's from California. Federal law sets an election day, not an election week, not an election month. In fact, an appellate court in another Judicial Watch lawsuit ruled that counting ballots received after Election Day violates federal law. It undermines election integrity, undermines confidence in the people in the fair administration of the elections, and of course, violates federal law.
So Congressman Issa graciously gave thanks to Judicial Watch for our support. I'm grateful to have Judicial Watch's support in this important lawsuit. California voters need all the help they can get to ensure fair elections. That's for sure. And as I noted, California's counting of ballots that arrive a full 7 days after Election Day, it encourages voter fraud. Because you know on Election Day how many votes are needed to get your candidate over the top. And so you know how many votes you need to get in there, potentially unlawfully. Now, do you have a system that completely curtails fraud? Of course not. But you also have systems that reasonably are set up to make sure that the worst type of fraud isn't encouraged and made difficult to catch. And plus, you follow the law. The law is there's an election day. You can't extend it for a week. So we had this Election Day lawsuit in Illinois. We have this Election Day lawsuit in Mississippi that led to this massive appellate victory, appeals court agreeing with Judicial Watch's legal analysis. I mean, we were first out of the gate on this in terms of successful litigation. I mean, we are leading the way in ensuring that only votes that are counted are the ones that arrive by Election Day. And this is a major lawsuit in California. Everyone acknowledges California is a mess. So we've got ongoing lawsuits in California, Illinois, and Oregon to clean up the voter rolls there. Supreme Court fight on Illinois' counting ballots that arrive after Election Day. Mississippi fight, which we've largely won on counting ballots that arrive after Election Day. and we just initiated a new lawsuit against California on counting ballots that arrive after Election Day. And it's only March 14th. So there's a lot more coming. There's a lot more heavy lifting from Judicial Watch to ensure that your elections are fairer and cleaner and reflect the fact that America is not a third world country when it comes to elections. Great stuff Judicial Watch is doing. And if you're not supporting our work, you should be. If this isn't reason to do so, I don't know what would be. I'll give you another reason to support Judicial Watch. It's our remarkable and successful effort to expose the full truth about what Fanny Willis was up to in her illicit, in my view, targeting of Trump and abusive targeting of Trump and unethical targeting and handling of the Trump cases. Just remarkable success as a result of one FOIA lawsuit, one open records lawsuit under the Open Records Act of Georgia. Now, we knew or suspected that Fanny Willis was coordinating with the Biden operation, Jack Smith, and the Pelosi January 6th operation. We asked for records. She denied she had records, didn't even show up once we sued for the records in court. She was found in default, which means you didn't answer the darn lawsuit, which is just incredibly, let's put it this way. Judicial Watch has been doing this work for 31 years, hundreds of FOIA lawsuits, and we pretty darn well know about other FOIA lawsuits out there. The idea that a government agency of any type would just not show up and answer a FOIA lawsuit, be found in default, is historic in a bad way. But that's what Fanny Willis did in her office, and she was found in default and ordered to pay us $22,000 as a result. But it didn't stop there. As I was talking about last week, there was a hearing, and because we wanted a special master to oversee the records of the case. Because she said initially, I don't have records. And then she said, oh, we do have records, but you can't have them. And so there were like half-baked searches. They didn't know where they were looking. They didn't look completely. It was a complete disaster. They didn't show up, and then they're playing games and being dishonest with Judicial Watch, in my view, the court. So that's why we wanted a special master, someone to oversee the search. So the court had the hearing, as we talked about, and he orally ordered them to turn over the new records that they found, 212 pages of records. But then he issued a written order that not only, kind of verified his oral order, but slammed Fanny Willis's misconduct in this case. And I'll read you a good section of it. It was just ordered on March 7th. No, it couldn't have been March 7th. I think it was issued this week. But maybe it was. Well, actually, I have the order here. Let me look, see what the date is. Yeah, it was filed March 7th. Took a while to get to us, I guess. In August 2023, Plaintiff Judicial Watch submitted an open records request to defendant District Attorney Fanny Willis, seeking, quote, all documents and communications sent to, received from, or relating to Special Counsel Jack Smith, and all documents and communications sent to or received from the United States House January 6th Committee. Defendant claimed to have no responsive records. Doubting this, plaintiff sued and has since secured a default judgment against defendant, who it turns out does have responsive records. After several non-searches, one court order, and at least one actual search of unknown thoroughness, defendant revised her answer in essence, I do have records, but you can't have them except for this one record you already have and gave me. This is a Fulton County judge, state court judge, talking about the district attorney of that state, of that county, Fanny Willis. Just incredible. Unsurprisingly unsatisfied with this post-adjudication response, Plaintiff Judicial Watch on December 17th petitioned the court for the appointment of a special master to conduct her own search of defendant's files for responsive records and review the documents defendant has determined fall outside the ambit of the state's open records law. So the records they're saying we can't get because there's an ongoing criminal investigation supposedly into Trump and all of that. And I would argue that she lost all the right to assert any privileges because she never answered the lawsuit in court. You lose. On February 28th, the court held a hearing, and that hearing we played for you previously here, on our motion for a special master, which both sides presented argument and made various factual representations to include an assertion that the universe of responsive documents consists of 212 pages, some of which may be duplicative. I love when government people tell you it's duplicative. You know what they're saying is duplicative? They say this is what they consider to be a duplicative email. Let's say I send you an email to your John Jones. Hey, John Jones, I need you to do this for me ASAP. And John Jones forwards that to a third person, Betsy Jones. Betsy, I need you to do what Tom said, and you need to do it quickly. So how many emails is that? That's 3. The government would say, well, that's duplicative, and you can't have all 3, There's the email I sent to John Jones. That's one email. And then there's the email that he forwards on. That's a second email. Maybe it's just 2 emails. But you see my point. And they're telling us that that's duplicative, so it only counts as 1. That's not true. Each separate email is a different record. And it's used as an excuse to hide records from us. I mean, it's not just a difference in counting records. They say, well, that's duplicative, so you can't have it. From these presentations or representations, the judge goes on to say, so he says, I heard all these arguments. I heard these new factual representations made to me. The court rules as follows. No special master will be appointed for now. Too bad. But we haven't given up hope. Defendant shall, through counsel, deliver to the court within 5 business days of the entry of this order all records defendant has identified as being responsive to plaintiff's request, but which are being withheld pursuant to one or more of the exemptions. Along with the documents, defendant should provide a list of indicating which documents arguably fall under which exemptions. So tell us what's going on here. Why are you turning the documents over, and be specific? And he also wants a detailed description of the search and the search terms. Now, if it were a federal FOIA case, we would, there'd be a little bit more clarity as to what the requirements are since the law has been laid out here. But we're in Georgia State Court, so, the court, can kind of seemingly do what he wants to do here. I'm not sure about that. But in the end, we now know there are 212 pages of documents, and the federal court ordered Fanny Willis to turn them over to him. Why? Because he doesn't trust her. Now, what is he going to rule? Is he going to rule that, the privileges are overcome and, that's going to be more briefing in the future? But Fanny Willis was slammed in this, and I read you the court order. I mean, the court is mocking Fanny Willis, making fun of her behavior in this FOIA lawsuit. And it's a pretty darn important FOIA lawsuit. It's or Open Records Act lawsuit under Georgia law, because it gets at the heart of what was going on with the targeting of Trump. Who was behind it? Was it organically rising in various jurisdictions? Or was there a grand conspiracy, as is largely being confirmed, to target him, run out of Democrats' offices in Washington, D.C., whether it be in the White House and Justice Department, or, as has been confirmed, the Pelosi operation through the January 6th committee? So there's a lot more information we want. It's a victory for accountability. Fanny Willis is being hauled before the court repeatedly as a result of her misconduct. Remember, she has been thrown off the case because of her conflicts of interest and her ethical, blindness? I don't know, maybe that's the charitable way of putting it, in hiring her boyfriend to run the investigation into Trump. I mean, by all accounts, based on my analysis of what went on, I mean, it's even like more base than just the Democrats wanting to get Trump. She wanted to do this criminal prosecution of Trump to launder money for her romantic relationship with her boyfriend. So Judicial Watch has a number of lawsuits on this abuse of Trump. And, and I highlighted last week that, we've got to get these records out. I mean, we've got the Trump Justice Department under Pam Bondi going into court last week to defend Biden administration withholdings of who USAID is giving money to. I was just on a hearing this morning as a client. Our lawyer was arguing for us, Michael Bekesha. We're involved in a case with the Justice Department over the text messages of Peter Strzok and Lisa Page. 6 years they've taken to turn the records over. They began during the Trump administration. And now they say, well, we'll complete the records that we're going to give to you. We will finish review and have them over to you by the end of, I think, the month. 6 years later. And then now we have to litigate over the records they withheld. I hope things change after under the Trump administration. I mean, just think of the categories of records that President Trump and his people should be focused on releasing now. Just think of the categories. The lawfare against him, Biden corruption, the Biden crime family, the cover-ups of his misconduct and criminality, the abuse of the January 6th event to target and jail Trump and other innocents, the censorship of American citizens, the Biden border invasion, the COVID cover-up, the China cover-up, the gain-of-function cover-up, the election integrity mess, the efforts to suppress concerns about how the elections were conducted in 2020 and beyond. I know there's this focus on Epstein records, there's this focus on JFK records, but I tell you, our republic was almost destroyed as a result of some of the scandals I'm talking about here. And I'm not saying you shouldn't be outraged about any Epstein cover-up or such, but that wasn't going to make or break the country. The categories of documents I'm talking about were part of an effort to destroy America and our Constitution and Republic. And so this Fanny Willis collusion fight, it's part of that. So I'm glad the court ordered more disclosure there, because I think our country needs it if we're going to be around much longer. I'm serious. Because we can't have President Trump in office for 4 years and have no advancement to the accountability that nearly destroyed the country. Because what would happen is, if a different category of politician got in, we'd be back to square one because nothing's been done. There have been no consequences. Accountability and consequences come from the disclosures. So that's why this Fanny Willis lawsuit and our other lawsuits for all of the issues that I'm talking about are so important. And we're not going to stop. We're simply not going to stop. There was this story last year that I think kind of shook a lot of people. and a lot of people who aren't normally interested in politics. And it was the home invasion by state bureaucrats and the taking of 2 family pets and then the euthanizing of those 2 family pets that shocked Americans to their core. And it happened in New York State to poor Peanut the squirrel and the other pet. I don't know if we have video, Fred the raccoon. So this couple had these 2 animals, which are typically wild. I guess that's what the bureaucrats would say. Oh, they're wild animals, so we got to go get them. Of course, they didn't need to do that. So they raided this man's home and took those animals and euthanized them because I don't know why. I mean, there have been a variety of reasons why. And people are outraged. You come in and take a man's pets for no good reason and kill them? So Judicial Watch being what Judicial Watch is, we asked some questions of state authorities about what went on at that raid. It got national headlines. It became a point of contention in the presidential election. And what happens is you get these battles during presidential elections and we're supposed to move on. I mean, this was a wild abuse of power by all accounts, so we want some information and accountability for it. So that's why we filed a Freedom of Information law. It's FOIL in New York. Lawsuit just the other day against the New York State Department of Environmental Conservation. Well, that's an interesting way of conserving our environment and our wildlife by killing pets. And we sued for records about the seizure, testing, and euthanizing of a squirrel named Peanut and a raccoon named Fred belonging to Pine City, New York resident Mark Longo. And this is the game that we had to, this is the gamesmanship we had to deal with up in New York, because there's a peculiar aspect to New York FOIL law that makes it a little more complicated to deal with. They can essentially grant themselves extension after extension, and you just basically how long you're going to tolerate. So we filed the lawsuit up in the state of New York after, it's in Albany County, after the Department of Environmental Conservation failed to comply with 2 requests for written and video records related to Peanut and Fred. The first, filed on November 6th, seeks records related to the seizure, testing, and euthanizing of the animals, including, again, Squirrel and Fred. And we want to know, what was the complaint that led to the raid? Oh, there's a picture of Fred. There's poor Fred. Their internal communications, and the back and forth. You know what we want. They know what we want. I mean, how many records could there be on that? Not many. All body-worn camera audio and video footage and dash cam audio video footage captured by the New York State Department of Environmental Conservation and its partner agencies related to this incident where they went to his home. And this is what happened. Since November, when we first filed the request, the state agency has granted itself 2 30-day extensions and then a 60-day extension to not respond to Judicial Watch's request. 10 government agents from the State Department of Environmental Conservation and Health reportedly showed up at Longo's home, where he operates an animal sanctuary, and took his squirrel and raccoon, later killing them. And this is the quote: "They treated me like I was a terrorist. They treated this raid as if I were a drug dealer. They ransacked my house for 5 hours." He told the New York Post that Peanut the squirrel, also known as P-Nut, P-N-U-T, was popular on social media. And of course, as I said earlier, that a lot of people were outraged about it. And I don't think you have to be a Republican or a Democrat to be outraged about it. It was on its face an abusive overreaction in the least by state agency bureaucracies. The heartless killing of Peanut the squirrel by New York State bureaucrats shocked America. And now these same bureaucrats don't want to turn over one document about Peanut's death and their abusive raid on Peanut's home. Judicial Watch's lawsuit aims to get to the bottom of this abuse of government power. So this is what I love about Judicial Watch. We've got our major federal lawsuit over California's this terrible election system that allows the vote of people to arrive 7 days after election and still be counted. We've got this major lawsuit over Fanny Willis. Major federal FOIA lawsuits over corruption like you wouldn't believe here in Washington, D.C. But these two pets of this man were taken and killed as a result of an abusive raid by some environmental agency in New York. And we are on that as well. That's why I love Judicial Watch. That's why you should love Judicial Watch. Because I don't want to overstate how important this is, but this is pretty darn important in the sense of this contempt for the rights of citizens. This is obviously about the man's poor pets being killed. That's right. But think of the constitutional issues involved in raiding a man's home over a dispute about a wild animal he may have been keeping as a pet. Incredible. And I don't remember if they were armed, but it doesn't matter. I mean, it was a danger. It's just an inherently dangerous situation to go, and the police will tell you, be the first ones to tell you this. To go in with a raid like this is dangerous. It's dangerous for the police or law enforcement or the personnel involved in this case. It's dangerous for the families or the owners and the residents of the home. So rather than protecting the public, in my view, this raid endangered the public safety, and these two poor animals were killed as a result. And Americans, and I think this is fair to say, most people elsewhere in the world don't like it when innocent animals are killed by government officials in this blasé way. And we want the truth about what went on. What's the state secret, Albany? What's the state secret, New York State? So I'll let you know if we get any Peanut documents. You know, we've talked a lot about censorship here on this program because we've been censored. I've been censored. I just had an election video censored on TikTok. I was banned from TikTok, and then they let me back on. Or maybe they didn't let me back on, but anyway, I'm back on. And I only have a few hundred followers, so it's kind of a baby account in that regard. But I posted a video of my talking about our election work, our lawsuit challenges to states for counting ballots that arrive after Election Day. And they censored the video. The Chinese communists run or controlled TikTok censored the video. Took it down, violating community standards. I still don't know why it's been taken down. But it's not just TikTok, because it's bad enough that, the irony is TikTok is actually following the lead of other, at least in the past, of other social media platforms run by freedom-loving Americans, allegedly. And YouTube took down a video of me, this literally one of our weekly update segment videos, of me talking about Judicial Watch's election integrity work in the days and weeks before the election in 2020. And it was done at the request of the California Secretary of State's office. And we found out about that as a result of a Judicial Watch FOIA lawsuit. We sued. Because, as I said, we sued California Secretary of State. And they settled a lawsuit with us to clean up the rolls. I talked about them cleaning up the rolls. Evidently, they didn't like what I was saying, and they retaliated against us and took action by asking YouTube to take our video down, which they did. Just weeks before the election. I think it was in August of 2020. See, I started off calm. Now I'm getting myself angry about it. But it's outrageous. And the federal courts in California, in my view, have mishandled this, and now we're asking the Supreme Court to step in and step up to vindicate the rule of law against this government abuse. We filed the brief with the Supreme Court asking them to take our case, Judicial Watch versus Shirley Weber, in her official capacity as a Secretary of State in the state of California. This is the brief. It's interesting. So when you file cases with the Supreme Court, you basically have to go to these special companies that print the briefs out in the style and format that the Supreme Court likes. I guess the judges all want to be able just to read the briefs and things they need to read in these little booklets. I don't know if we file them online as well, but so anyway, this is the actual brief, and it's a good brief. I encourage you to read it because it tells a horror story about our civil liberties, about government retaliation in the days before an election to punish us for telling the truth. And basically helping people and educate people about election integrity threats. We filed the lawsuit in September of 2022, and so now it's almost 3 years later and we're before the Supreme Court. And on September, it's actually, I thought it was in August, but it was a September case. It was September that September 2020, it was September of 2020, the end of September, that the censorship occurred. Judicial Watch posted on its YouTube channel a video entitled Election Integrity Crisis, Dirty Voter Rolls, Ballot Harvesting and Mail-in Voting Risk. The 26-minute video featured me discussing the vote by mail processes, changes to state election procedures, ballot collections, sometimes referred to as ballot harvesting, another abomination, and states' failures to clean up their rolls, among other topics, including the failure of California to clean up their rolls. Fitton's comments, my comments, were informed by successful lawsuits brought by Judicial Watch against the Los Angeles County and the Secretary of State, California, in 2017 to compel the county and the state to comply with the National Voter Registration Act voter list maintenance requirements. For instance, in June 2019, this is at the time, Judicial Watch was informed that Los Angeles County had sent notices to 1.6 million inactive voters on its voting list after a settlement agreement had been reached. Pretty good indication that the rolls weren't clean if they had to send out 1.6 million names, isn't it? Judicial Watch uncovered the California Secretary of State's monitoring of Judicial Watch's videos for months leading up to the 2020 election with the help of a public relations firm closely connected to the Biden presidential campaign. And we uncovered that through our own FOIA. So we were investigating the censorship, and lo and behold, we found out that we were a victim of government retaliation and subsequent censorship at the behest of the government by YouTube, which is run by Google. So what is the legal issue for the court to explain or to handle at the Supreme Court level? And I'm trying to think, are you going to be interested in it? I think you might be interested in it, right? Because I think it goes to the heart of what we tolerate and what the law tolerates in terms of government abuse of its citizenship, of its citizens. Let me read you a little bit of the brief. Contrary to 11, well, I'm quoting from the press release here, so let me get the page here. Contrary to 11 other appellate circuit courts in the country, the Ninth Circuit, which is the appellate court that ultimately handled our case, because we filed it there in California, has made it more difficult for citizens and groups trying to hold government agencies responsible for retaliating against these citizens or groups for First Amendment protected speech. They didn't like what I was saying. They didn't like what Judicial Watch was saying. They didn't like what you were hearing and wanted to stop you from hearing it. So in many ways, you're a victim of this censorship and this adverse retaliation against Judicial Watch. Until this case, every regional circuit, so all the other appellate circuits, had held that an adverse action in the First Amendment retaliation context is one that would chill a person of ordinary firmness from continuing to engage in protected activity. Chill a person of ordinary firmness from continuing to engage in protected activity. So what does that mean? If a person of ordinary firmness found out the government was watching what they were saying and was prepared to go to their social media platform of choice and ask that their content be taken down, would that chill their speech? You bet your bottom dollar it would. And that's what happened in California. The Ninth Circuit strayed from its sister circuits, excising the chilling effect inquiry from the universally accepted standard. It ruled that the Secretary's course of action was not adverse, completely new standard, and therefore not actionable, so we couldn't sue. But they didn't define what adverse action meant or analyze whether the course of action would chill a person of ordinary firmness. So basically what you're telling the Supreme Court and what Judicial Watch is telling the Supreme Court in this brief is that there's a split. You have the Ninth Circuit. It's making it easier for the government to abuse citizens. Every other circuit court that looked at similar issues as ruled in a way to make it easier for citizens to stand against government abuse. The Supreme Court should not give a green light to California or any other government to retaliate against Americans for exercising their free speech rights. Simply put, California's retaliation against us led to YouTube removing and censoring our accurate election integrity video just before a presidential election. What does that sound like to you? The Biden PR firm was working with the California Secretary of State's office to monitor us, and once they found that we were saying things they didn't like that could be unhelpful to them or made them angry, they had our video deleted by asking YouTube to take it down. Sounds like election rigging to me. I don't know what it sounds like to you. And we've been separately uncovering instance after instance, detail after detail of broad censorship by the deep state, the Biden administration, of American citizens. And I encourage you to go and look at our various lawsuits and litigation about it. In fact, as we end, I will encourage you to read much of this issue, much more about this issue in my new book, Rights and Freedoms in Peril, an investigative report on the left attack on America. It details quite nicely in a summary fashion a lot of the censorship material that Judicial Watch was able to uncover as a result of our litigation. I mean, let me just be clear. The retaliation and the targeting of American citizens in retaliation for their speech, the censorship of American citizens in retaliation for their speech, we've never seen anything like it in American history like we've seen in the last few years. You had the deep state secretly doing it during the Trump administration. Trump wasn't telling people to get censored. It was these people who thought they could just start censoring speech related to elections and COVID. And it just got worse under Biden. Biden endorsed it from the White House. We've never had anything like it before in American history. And that's why our lawsuit here is so important. And our other lawsuits to expose the full scope of it are so important. This is another area where there needs to be significant, in my view, criminal investigations of the violations of civil rights of American citizens by bureaucrats at the federal and state level. But that's another matter. You know, that's the challenge, right? People say, well, Tom, why don't you put someone in jail? I can't. We're a nonprofit. We're not prosecutors, but we can get information out that other individuals with the powers to put someone in jail can pursue. So let's see what happens. There's more than enough evidence uncovered by Judicial Watch in scandal after scandal to justify criminal investigations and prosecutions. And let's hope there's a change of pace with the Trump administration, that we finally get the pursuits of those issues criminally in a way that restores America's confidence in the fair administration of justice and the end of a two-tiered justice system in this country. I've often observed it's not a double standard. The left has been perfectly consistent. Prosecute their enemies, protect their friends. That's the Obama way, and it's got to end. So with that, I thank you for your support of Judicial Watch. A lot going on, more to come, and I'll keep you updated on the latest litigation we just filed and other litigation that is coming home in terms of getting us documents that are going to really be astonishing to you. I know there's so much more we're doing that I couldn't even get to today. Maybe we'll get to it next week. Stay tuned for more next time on the Judicial Watch Weekly Update. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.